So friends, we are moving on to understanding Section 30 of the Indian Contract Act, which states that wagering agreements are unenforceable in India. This provision interestingly says that a person who has entered into a wagering agreement cannot bring a suit or cannot sue in the courts of law in India to actually have his agreements enforceable at law. One will understand that wagering agreements means one category of agreement which can be considered to be uncertain. Uncertain based on the kind of chance that persons are actually putting in the contract. Betting is considered to be a wager. Horse racing is considered to be a wager. Wager is nothing but some kind of gambling. And hence you will notice that very often than not we say that wagering agreements can touch the position of illegality. Now, illegality, friends, is about a statute, say the Indian Penal Code or the state police legislations or even the Public Gambling Act, which holds that certain kinds of activities are not only prohibited but also are punished. However, in the Indian Contract Act, there is no clear mention about whether wagering agreements are considered to be legal, because that's not what Section 30 attempts to do. The kind of illegality of the actions in wager are left to different other legislations. However, the contract law clearly only states this much, that you cannot sue for enforcement of these agreements. So that's the only limitation that Section 30 imposes on parties in India. However, Section 30 also starts with certain exceptions. Now, one will have to appreciate and understand that the Indian Contract Act was enacted during British times. It was drafted by Britishers, and they came in to make this law for India. And hence, they decided that horse racing can be an exemption and will not be considered as a wager. So, two parties want to enter or promise each other on horse racing, and they say, okay, if the other party races and if you bet on him, then some kind of a prize can be got out of that horse racing. So prizes from horse racing are enforceable as agreements, and an exception is created under Section 30, which says that any subscription above 500 rupees in a horse racing and towards the price of horse racing, that kind of a promise can be made enforceable. So it's not considered to be unenforceable in it. So I think very clearly anything that you bet on a horse is, according to me, it's wager. But there are exceptions to wager. That's how we have actually moved on, because we have appreciated that yes, in certain of these aspects, there could be not a pure game of chance. Now, horse racing, friends, is not purely on chance. It's not pure betting. It's about understanding the capacity of the horse, the history of the horse, whether it can win or not. It could also involve the skill of the jockey and so on and so forth. So I think the courts, even after independence, have consistently held something like this, that in case there is some kind of skill that is involved in any kind of a game, and you can actually say it's actually a combination of skill and chance, then such kinds of games and any kind of promises or exchange of promises or agreements in relation to that game can be made enforceable and will not be covered under Section 30. However, you should also appreciate that Section 30 does not prohibit any promise to pay the price of such kind of games, right? So a pure game of chance is something probably the courts may not enforce. And that's why you will notice that at times the courts in India have judged the fact that whether a game of chess, whether a game of carom, whether a game of cards can be considered to be wager. And the courts have said no, they cannot be, for the simple reason that when you play a game of rummy, when you play chess or when you play carom, there is an element of skill that is involved, and hence this kinds of games can be permitted, and they're not to be considered as either gambling or betting or wagering. Having said all of that, friends, you will notice that today most of these games have become online games. We see a lot of online gaming platforms that have been actually circulating in the market. And interestingly, if you look at the aspects of gaming and gambling, these are mainly not central government subjects. They are allowed vis-a-vis the states. You may have an online gaming system like Dreams 11 or so on and so forth. So there are many games that have, and the market is quite booming. But certain states in India may find that this is not permissible, so they may find it problematic. So in their state, they may not want to permit the same. But again, you will notice that the states cannot have discriminatory policies, and the same is under some kind of a scrutiny before the courts. And however, I think the point to be made here is, I think any kind of gaming which does not cause any law and order problem and is not a pure form of betting, it does, which probably see the aspect of betting as a form of behavior against public policy was that it encourages people to waste their money, gamble their money, invest their money into something that they may lose over a period of time. So, this was considered social evil in India, and even today, probably in some circles, we do consider gambling to be a social evil. However, you will notice that gambling, apart from being a social evil, is also a part of a rich cultural and customary practice in this country, in certain communities where such kinds of gamblings are permitted during certain days. So it's part of the ecosystem, and it has been part of the legal system for quite some time in India. There have been debates, there have been legislations, there have been police actions regarding the same, and hence that is where this becomes like a very contentious matter about what is permitted and what is not. Further, you will notice that in the state of Goa, casinos, and these casinos generally have a lot of gaming, and these casinos have been actually permitted to operate in the state of Goa because that is part of the tourism culture. So Goa has made an exception, so has the government of Sikkim that has made an exception. They don't find it problematic because it's good for their economy. Generally in Goa, they think that it is outsiders and not Goans who are actually getting into these kind of casinos, and casinos actually have some kind of gambling, and hence the state of Goa permits these kinds of actions. However, point to be noted, friends, is again this, that these kinds of actions under the police legislations or under any Goa or Sikkim special law can be permitted. But having said it, the enforceability of the same in a court may still be a problematic situation, considering that if it's wagering and if there is a promise or an agreement that is in exchange or a contract that is exchanged with these casinos, I'm not entirely sure how the law will actually operate, considering the legitimacy of the same. The courts in Goa may be inclined to interpret it because it has been legalized, but the legalizing of the same again will open up challenges in other states where such kind of gambling is not permitted. Also, don't forget that at one point of time, lotteries were a common factor in India. Again, bringing social issues and issues of public order. Lotteries in a lot of states have been now removed, right? The lotteries that existed in most states were governmental lotteries. They promoted some kind of state action. So the state thought that it would benefit social welfare, but again, I think there has been a complete revisit of the lottery schemes, and most big states in the country do not encourage lotteries. There are one or two states in the northeast who do permit these lotteries to operate, and hence you will notice that the wagering agreement philosophy in this country is not uniform. It varies from state to state, from game to game, from skill to skill, and this is something that the courts also grapple from time to time of what to permit and what not to permit. Finally, one of the interesting issues that came about was on the issue of derivatives. Now, you'll notice that in derivatives, or in share market, or in stock exchanges, or in commodity trading, where you talk about futures and so on and so forth, there was an interesting challenge. Suppose the bank gives you money for trading, right, or for investment in stock. Isn't that against public policy, and isn't that actually something to put in a wagering agreement? So, see, wager is where two people come together to put money or money's worth into something that is not sure or certain, or into something that is future that cannot be predicted or is not within the control of both the parties. That's the definition of wager, right? Putting money or money's worth in something of a future activity in which neither of the party has any interest or does not have any participation in. Now, stock market is also one form of gambling, is what people would like us to believe. but there has been legitimacy of the same through again law and state action. And to a larger extent, people have lost in stock market. People kind of bully in stock market. This is also a matter of public policy which the government has to take care. But it is also a form of investment that has been recognized. And hence, you will notice that while it looks to be kind of a wager, I think legitimizing wager through state action is one of the mechanisms to bring in enforceability of these kinds of contracts. Today, you will notice that something very similar of a debate is going on with crypto currency, crypto assets, and crypto. Again, the problem is it's nothing of a physical, tangible asset. It's again a gamble. Having cryptocurrency is probably what the Reserve Bank of India will have to decide. But crypto trading and so on and so forth are something that even the government would be keen to regulate, especially considering challenges of law and order from a cross-border or a trans-border perspective. Because again, today on the digital age, the real challenge is to look at regulation of entities that are beyond the territories of India, to look at regulation vis-a-vis the trading partners, and most importantly, I think it is the duty of the state to protect citizens, innocent citizens or investors who may actually lose money over a period of time. Now, if one sees the craze of cryptocurrency and crypto trading and so on and so forth, one gets reminded of a time in the 1980s and the 1990s when chit funds in India became all that very popular. They were promoted as small savings, but unfortunately, many of these companies went and defrauded. They closed down. Consumers were cheated, and a lot of fraud kind of elements did happen during those days. So I think people must be really careful, look at government regulations before entering into any kind of wager. I think wager has examples. Wager has a lot of instances. We can actually find those things in our day-to-day activity. But one must clearly note that contracts and agreements of wager are not encouraged by the Indian Contract Act unless they are permitted by any special legislation, as the case may be. Right. So that's the sum and substance of Section 30 as we see, and that's I think where we close understanding the basic foundational character of contracts in India. Now, interestingly, friends. After Section 30, you will notice that the drafters have a type of a contract that is there from Section 31 to Section 36, and they are called as contingent contracts. So, contingent contracts, friends, are contracts that are contingent of some kind of an event, right? So, if that event happens, then the contract or the promise is going to be made enforceable. That's what a contingent contract is. Does it have some kind of significance? Yes, it does. Because the courts very recently, especially the Supreme Court of India, has said that a force majeure clause in a contract, force majeure clauses are those clauses that include the grounds of frustration that may creep into a contract. And please note, force majeure could be because of act of God. That could include earthquake, tsunami, a cyclone, unprecedented rainfall, and so on and so forth. Or it could be due to act of men or act of nature, both combined together. And that's why we say the distinction between vis major and force majeure. Vis major is act of God. Force majeure includes act beyond the control of parties. So the Supreme Court has said that because you say force majeure and if that event happens, this will happen, right? So it is about that kind of an event that may impact the contractual promise. So it is something that is contingent. If that event occurs, the promise may not continue, but if the event does not occur, the promise has to continue. And hence the Supreme Court believes that a force majeure kind of a clause and an event in a contract is nothing but making it contingent contract or contingent clause or a contingent agreement. And hence contingent agreements, the classic notion of the same was not very much of a use, but today with the Supreme Court's intervention in saying the force majeure clause is a contingent kind of an event, it has assumed some and great amount of significance. Friends, we understand that the Indian Contract Act is basically based on the law of obligations, and the perfect law and obligation that the Indian Contract Act states and puts forward are in a chapter quite later in the Indian Contract Act, and they are called as quasi or quasi contracts. These kinds of obligations are stated in section 68 to section 72. I think they are very, very important and significant. And they have been kind of the bedrock of judicial decisions in contracts in giving the judges a kind of a weapon and a strength to actually impose obligations despite an agreement not being present. Now, we have already seen, friends, that irrespective of whether the courts find an agreement to be void or voidable, if one refers to section 64 and 65 of the Indian Contract Act, you will notice that the courts can intervene in both of these kinds of contracts. So if the contract is voidable, of course, you can claim damages. The court can set aside the contract, and the principal rule of unjust enrichment and restitution apply in voidable as well as in void agreements. So section 65 does give you remedies even if the agreement has been declared to be void. That means that, if it's in restraint of trade, in restraint of legal proceedings, or so on and so forth, any of these void agreements, section 65 does still apply. So no person can actually unjustly enrich from void agreements. Now, having said this kind of, remedies that are available, you will notice that in quasi contracts, the courts can also give you certain kinds of remedies in case there is no contract or that does not exist a contract. But the relationship between the parties resemble one to be of a contract. Now, one of the most important points here that one should note is section 68. Now, we have already discussed this in the past, but to reiterate, section 68, which is the starting provision in quasi contracts, states that in case you have supplied any goods to an incapacitated person, and that incapacitated person could be a minor, it could be a person of unsound mind, or any other individual, if goods are supplied to him. Now, the point is, you will notice that these kinds of incapacitated persons cannot make a contract, but goods still have to be supplied to them. They have to live, they have the right to food, clothing, and shelter. And those goods that are supplied to an incapacitated person are the necessaries of his life. The contract may be void or voidable, right? That's one of the options that the courts can decide. And we have looked at the Moheri Bibi case, the Khan Kul versus Lakasid case, and so many other cases. The courts have that provision to decide that. However, the provision under section 68 very clearly says that if these goods are supplied to a minor, forget what is there in terms of enforceability of the contract or validity of the contract. The minor or the incapacitated person still will have to pay for those goods that are supplied. So, incapacitated persons have an obligation, irrespective of the contract being valid, existing, or voidable, to actually pay for those goods that were supplied to them and the goods that they have utilized. Right? So this is where the law of obligation comes in. Law of obligation is quite higher to the contractual obligation. Right? Even an incapacitated person cannot unjustly enrich, cannot make use of the goods while the contract in which the goods were given to him has been held to be void. Right? If the incapacitated persons use those goods that are of necessaries of life, please note under section 68, they may be asked to pay for those goods. Right? This can be asked from the court of law. However, the interesting point over there is usually they are not personally liable to pay. Their estate or property is going to be held accountable for payment. But which means incapacitated persons who have been supplied goods of necessaries of life are bound to pay. They cannot be unjustly enriching from contracts and goods that people have given to them out of the sympathy or without knowing or not knowing, irrespective of that knowledge that exists. Section 68 does not make those kinds of description. So, obligations of incapacitated persons are something that quasi-contract actually starts off with. Now, why do you say these are quasi-contracts or quasi-contracts? It's for the simple reason, friends, the term quasi means semi, partial, half. So it's not full contract, it's semi-contract. So it looks to be like a contract because look, giving goods to a minor is nothing but a contract. But because he's minor, because he's about less than 18 years of age, the courts and the law does not recognize that kind of a contract. So it looks to be like a contract, but it is a semi kind of a contract. It has obligations that the law imposes. Now, please note, what is there in section 68 is the obligation of the parties. Whether you have agreed to it or not, those obligations exist in law, and those obligations can be held enforceable by Indian Contract Act. Which also lays down this very interesting facet, friends, that the Indian contract law is supposed to be a law of private obligations. It is supposed to be law of private remedies. It is supposed to be a law based on agreements and obligations accepted between the two parties. So it's not externally imposed obligations. Largely, the contract law deals with private obligations, voluntarily accepted obligations, and not externally imposed obligations. However, when you see quasi contracts, you will notice that the obligations under section 68 are externally or legally or statutorily imposed. Whether you like it, whether you accept it or not, you would still be bound to pay, right? So there is an obligation under section 68 for incapacitated persons to be held accountable for the goods that are supplied to them as necessaries of life. So they would have to reimburse the person who has supplied it. This interesting terminology that is used in the Indian Contract Act, they don't say it is payment of the price. They don't say that. It's also not stated that it is damages that have to be paid. It is about reimbursement. So I think reimbursement clearly involves just the cost of those goods and nothing more than that. It's like paying back after that obligation has been completed. That's how section 68 would be actually coming into force. And you will notice that that kind of an obligation does exist under the Indian Contract Act, even for those kinds of contracts which can be considered to be void. Now, second, provision that is of interest to many of us is a very interesting provision which puts in an obligation on a finder of lost goods. Friends, section 71 says that, look, if there is a finder of lost goods, so what is a finder? Anyone who finds someone's product, right? So it's like it is reversed to the fact that I have lost something, I ask you to go in search of it. That's an agreement. If I ask you to go in search of lost goods, that's an agreement. This is reversed to that, which means there are lost goods and somebody finds it. Now, if you find someone else's lost goods, interestingly, under section 71 of the Indian Contract Act, there is an obligation, whether it is asked by the true owner or the real owner or not, you have an obligation in law to actually find the true owner of these lost goods and return the goods back to that true owner. That's the very interesting obligation that section 71 imposes. So you have no authority in law to keep someone else's product. In civil law, you're obligated to return it back. You're obligated to find who the true owner actually is. Now, when you compare section 71 to the aspect of, say, bailment contract, you will notice that the finder of lost goods has to really find the true owner, and he has to return it back. And interestingly, he can only incur 2/3 of the expenses in finding the true owner. Only that's all he can recover. So he has the right to be reimbursed 2/3 the economic value of that lost goods in case he has incurred expenses in finding the true owner. That is the limitation that is imposed under section 169 of the Indian Contract Act. So which means you will notice that if you are in possession of someone else's property, you have an obligation of a bailee, right? This is a kind of an involuntary contract of bailment. And your obligation under the contract of bailment can be imposed for taking care of the goods and in incurring expenses to take care, to find the true owner, and how much you can recover has been stipulated over that. The limitation is 2/3 the economic value of the goods is what finally you can get in case you return it to the true owner. Additionally, you will notice, of course, if you don't find the true owner as a bailee, you can always exercise the right of lien and the right of sale. That's something that finders can obviously do. But the point that you have to take note of is the finders have to find the true owner. This is an obligation that is imposed by law. And you will notice finder of lost goods can actually occur in many circumstances where, say, the railways, right? They have a lot of these goods that are unclaimed property. If you go to the airport, again, you will notice there are a lot of unclaimed goods. even in the airports, in the baggage counters, even in the cargo counters. Similarly, if you go to the port, again, you will find a lot of unclaimed goods. Now, in many of these circumstances, you will notice that unclaimed goods may also be considered in those circumstances, the port authority, the airport authority, or the railways to be having obligation under Section 71 as the finder of lost goods, also additionally having an obligation as a bailee of those goods, right? So the contract was to make the goods reach from destination A to B. That they have already done. But in destination B, where it is the arrival destination, no one has picked it up. Now, anyone who has the custody of the goods may have a role as the finder of lost goods. And that's how the obligations in contract are necessarily to be imposed. Interestingly, one other very interesting provision that you see in quasi contracts is Section 72. And this has been widely used till probably the income tax was amended, in which any kind of overpayment of tax, the income tax department now has a specific obligation to give you the refund of that kind of a tax. Now, till the Income Tax Act came up with that specific provision, now you know that the Income Tax Act is a 1961 law. It has been amended from time to time, probably every year. And there was no specific guarantee of the refund, right? But the courts have said, and very interestingly, they have used Section 72. You know what Section 72 says? It simply says that if someone pays you some kind of money by some kind of a mistake of calculation of tax, or mistake in terms of what I was supposed to pay in the contract itself, right? I pay over how much ever I am due to pay you. Look, the law of unjust enrichment, how beautifully it applies over here, that even the government, through taxation, or even anybody else through a contract, or any other way in which some money is paid over and above what was actually due, then in those circumstances, if you have paid that extra money by mistake, and this is not mistake as per contract law or use of contract law, mistake, this is mistake in terms of general common English parallel market kind of a sense, then in those circumstances, that money has to be returned back. So we have several judgments where the income tax department and the government were asked to return the money back under Section 72. It's an obligation. Now, you don't pay tax necessarily through a contract, right? It's not an agreement to pay tax. It is like you have to pay, right? Whether you agree or not to pay, that money goes. And hence you will notice that Section 72 applies even in those relationships that are not contractual, but look or resemble to be a contract. And the government has been asked to give that refund under Section 72, not to unjustly enrich from taxpayers' money, which probably by mistake they have miscalculated and actually paid to them. Now, I think the Income Tax Department has a very specific obligation to give the refund, and that too within a stipulated time. So times have changed, but I think Section 72 has been the bedrock. It has been the kind of a foundation to how anything that is paid by mistake, either to the government or to private parties, can and should be given back. And that is how quasi-contractual obligations, irrespective of contract, obligations beyond contract, obligations that are imposed by law, they are something that you can see gets stipulated over here as well. Finally, you will notice that quasi-contracts also very interestingly says something like this, that look, if you are enjoying someone else's services, let's assume those kinds of services, like for example, I'm an elderly person, and someone comes to see me every day, right? Take care of me, give me medicines, and so on and so forth. Now you will notice that it's not necessarily that I've promised him something, that's why he's coming. But he's coming, he's taking care of me, and this amounts to something that is happening for a long duration of time. Now, if it is a non-gratuitous act, right, and I am enjoying someone else's services of this non-gratuitous act, then I may have some kind of an obligation to pay. May not be now, but at some point of time, in terms of at least reimbursing the expenses that he may incur in giving me those services due to the non-gratuitous nature of those actions, right? So, whether I made a specific promise to him or not, whether there is a contract between me or him or not, if he just comes and looks at me, I think most people don't want to spend their own money in taking care of some elderly persons, at least, buying medicines or whatever is the travel expenses. I think that kind of a basic reimbursement is what that man can expect in law. Because I am the person who is enjoying that man gratuitous act, I owe an obligation to him to actually reimburse him that kind of an expenses. So clearly, friends, you notice that the purpose of the sections in this chapter called quasi contracts are very clearly to bring in obligations to those kinds of relationship in which no specific promise has been made. You cannot probably have an enforceable contract, but still, when you look at justice and equity and good consciousness, when you look at the principle of unjust enrichment and the law of restitution, the courts, as courts of equity, may expect the enjoying party, the party who has benefited from the supply of goods, the party who has someone else's product, the party who has this extra money, to actually give it back. That's precisely how quasi contracts actually works, and I think it's a very beautifully crafted provision in the Indian Contract Act, which clearly establishes the strength on the law of obligation, that I owe an obligation to someone else simply based on the fact that unjust enrichment, restitution, equity and justice demands me that I should reimburse him the kind of expenses that he has incurred, or the extra money that I have actually been making due to this kind of an action. So that, I think, should be a good aspect on understanding quasi contracts. And interestingly, you'll notice in quasi contracts, you can have very interesting cases of employment as well. For example, the Indu Mehta case or the PCE Vadwa case. These are very extraordinary circumstances when the court said, look, when the government has decided to take some employees, right, they have done their recruitment process. Now, very often than not, these recruitment processes are challenged in the court of law, and it takes around 2 or 3 years for the court to decide whether the recruitment is legal or illegal. Now, let's imagine that the courts after 3 years decide that the recruitment is illegal, right? Which means it is illegal from the time very beginning, and hence the entire employment is kind of cancelled, and the employee's employment is severed, right? Now, can the government at this point of time recover the salaries that they have paid to them in those 3 years? Because the court now has said, no, these are employments that are illegal. Again, you will notice that the government has enjoyed the services of the employees for the 3 years. They have worked. And the employees, when they have worked in a non-gratuitous nature, right? So, it's of no point of government to say, okay, the employment is illegal, it has been severed, it has been cancelled, and let's just recover the salary back, because already the government has enjoyed the services of these employees, and hence any such recovery is not going to be made possible at all, right? So, having benefited from the non-gratuitous nature of the employees, I think the employees do not owe any obligation to give the same back, right? So, I think that's how, interestingly, the reverse of quasi contracts can also work, and it can be a great defense in certain cases and in certain matters as well. So a lot of application of quasi contractual principle can be seen even in current day modern times, and that makes this as a very, very interesting provision altogether.